Okay, and our third speaker, my colleague, Anna Santos-Ruchman, who's with me at the law school here at St. Louis and in the Center for Health Law Studies. The floor is yours.
All right, thank you very much, Dr. Kuhn and Bander Center, for inviting me to be here today. And I realized that this is peak post-lunch period, and I'm the third lawyer in a row that you're exposed to. You've probably also realized I'm not the cool one because I don't have purple shoes, I don't have neon green socks, but above all, I have a lousy presentation title. When I looked at it yesterday, I thought, what did I mean by monism and legal reactivity? And in truth, this is the real title of the presentation. A few of my favorite puzzling things, and I promise I will not sing a song, but here's why I think it might be useful for a community like you to hear from the perspective of somebody who doesn't have anything to do directly with AI, but thinks about AI and the role of the law in structuring the ways we interact with the AI, why I think figuring out what some of the concerns of people like me, potential advisors to regulators, potential writers about the role of law in implementing AI on a daily basis might be relevant. So here's what I'm going to do. I'm going to start with a set of propositions about artificial intelligence that I absolutely think are true. As you will quickly discover, they're also mutually incompatible, at least to a certain extent. So I beg some understanding from you as I go through these apparently conflicting propositions. After I do that, I will then explain what I mean by monism and why I think we have a problem about the ways we think about artificial intelligence in the legal profession, except when we have thoughtful people who think narrowly about an area, like Professors Price and Haupt. Unfortunately, a lot of the regulation that we see out there, and this is not restricted to the US, as I'll show you, I think, in a moment, are not as careful of framing the issue. So we end up using AI in ways that I think can be detrimental from an innovation perspective and also ultimately from a patient perspective. So here we go with the propositions. So first, favorite puzzling thing about AI for me, artificial intelligence does not exist. And I truly believe this. This is what I mean by this proposition. Artificial intelligence is, as a concept, absolutely meaningless. Artificial intelligence, if taken to be what some of the early visionaries in the fields described it to behave like, is something we have not achieved and are very, very unlikely to achieve. I apologize in advance if I repeat anything that was said in the morning. I was downtown teaching FDA. But in case you have not alluded to the different concept of artificial intelligence, when I say artificial intelligence does not exist, I'm thinking of a Turing-like version of artificial intelligence. A Turing test-like version of artificial intelligence says artificial intelligence only really happens if when a certain computer program performs a task in a way as it would be performed by a human. So if I see the outcome of the use of said program and I cannot distinguish between the machine and what a human could do, there's a substitution degree. So there we have intelligence, it's non-human. So this was one of the early, and to some people still the holy grail of artificial intelligence. And right now, we're nowhere close to having an AI status quo that mimics this reality. So if you really think that artificial intelligence is a form of intelligence or something that gets us very, very close to a form of intelligence performed by machines, that's a form of futurism that it's so far removed from what I can conceive right now that I can't but say artificial intelligence, at least in that form, does not exist. And yet, as you probably know, a lot of the documents that emerge from regulatory authorities and policy making bodies say, let's regulate artificial intelligence. So what do they mean? If this is what you mean by artificial intelligence, general purpose intelligence, human substitution, the concept is either something we have not attained or something that doesn't make sense from a practical perspective. So let me say the exact opposite. Artificial intelligence does exist, but it suffers from a Walt Whitman-like problem. It's a number of different things. It contains multitudes, and some of these things are compatible, some are actually quite the opposite. So I don't know if you discussed this in the morning, but to some people, artificial intelligence has little to do with substitution or actual intelligence. I've heard that alluded to in previous presentations. Artificial intelligence could be something simpler, like machine learning. It could be something a little bit more complex, like deep learning. It could be one of the many forms of deep learning, semi-supervised, unsupervised, etc. And I'm not going to go into these categories because I'm not an expert on each one of them, but forms of artificial intelligence do exist when we start talking about the things you've been talking about since early today. So if we are talking not about the, I would say, almost utopian forms of artificial intelligence, again, things like deep learning, possibly you've heard the concept of weak AI or narrow AI, task-specific programs, I will freely concede that artificial intelligence does exist. Yet, most of the headlines that you see out there, and they are often either lifted from, inspired by, or implicitly inspired by regulatory and policy-making positions, they don't differentiate. When you hear people talking about artificial intelligence, and often this distinction is not made. And I'll revisit this topic when I try to explain why I call this a talk on artificial intelligence monism and what the problems with this view are. For the time being, allow me a couple more propositions. First one, artificial intelligence is fundamentally different as a matter of technology from everything else we've ever encountered in the field of technology in healthcare and outside healthcare. We've seen, not just from the legal perspective side of things, but through presentations throughout today, the many iterations of the current status of different types of AI technologies. And they have some things in common, but this is quite the first time in the history of technology that we've come to rely this much on algorithms, that they have the ability to aid decision-making processes, to do things like automate drudgery, etc. So this is fundamentally different. We're relying on old-ish technology, algorithms, computer programs. This is not the mid-20th century anymore, but we've now elevated them to a degree that there's this autonomous field loosely defined as artificial intelligence that's fundamentally different from a practical perspective, from a conceptual perspective, from everything that we've known so far. And you can probably guess now I'm going to say exactly the opposite, right? So artificial intelligence is not fundamentally different from everything that we've known so far. And what I mean by this is that essentially we're using algorithms, mathematical formulations, granted on steroids, but we're using mathematical formulations and forms of inference to come to certain results. All of this is done to aid decision-making processes or do things like automate drudgery, but we've done that with things as simple as alarms and clocks back in the day, to phones and the like. So artificial intelligence is essentially algorithms on steroids, but it's not fundamentally different from the things we've encountered before. And this might be relevant from a legal perspective because when you try to decide which doctrines apply to artificial intelligence manifestations, it might be that we don't need to go searching for something absolutely new. We just need to look at the proper analogies, which is partly what you saw my two colleagues do earlier today. And instead of reinventing the wheel, we just try to use older laws and see how they play out in this particular field. And if you think this is something that's of little concern, what does it matter if we create laws from scratch, or if you're just inserting artificial intelligence-related problems in a continuum of legal decisions, case law, etc., I hope to persuade you that that's actually a very important thing with very real consequences. Final proposition, I promise I'll stop with the conflicting arguments. Final proposition, and this one was not in my original plan, but given the view out of the room, I feel that I should talk about the weather. So, final set of propositions. This is the spring of artificial intelligence. And part of the weather comments come from the fact that this weekend I read Professor Mitchell's new book, which does talk about the spring versus winter of artificial intelligence, and she's up on the next panel, which I greatly look forward to. But what do I mean by the spring of artificial intelligence? This is the dawn of it all, right? We are now seeing a lot of new exciting applications, and no other field is as exciting as the field of healthcare artificial intelligence, because we'll be able to solve problems and help people. So spring of artificial intelligence, because even if you think, like I probably also think, but I just don't say it too loud, that artificial intelligence does exist, you probably agree that we still have a long way to go. At least that seems to be the hope in the room. So this is the spring of artificial intelligence. What does that mean from a legal or policy-making perspective? This is where the decisions we make about how to regulate artificial intelligence are incredibly important. If we get it wrong, we can stifle the field. Say we get liability wrong, we can just stifle certain very, very socially useful uses of artificial intelligence. Imagine that we don't set the appropriate regulatory or legal incentives for the production of AI technologies or technologies that incorporate AI. Well, we get that wrong. We don't get those technologies in the first place. We use biased data or contextually biased data right now. We'll pay for that down the road, and probably we're already facing some of those consequences. So the spring of artificial intelligence is when some of the legal and policy-making decisions will matter the most, because they will shape the future of the field. And final time, I'll say the opposite. This is not the spring of artificial intelligence. This is the winter, which is more in line with what I'm seeing out there. So this is the winter of artificial intelligence. A lot of people have said, well, yes, the things that we're all saying and celebrating in this room about artificial intelligence were said pretty much in the 70s and in the 80s. And where is all the promise that we were talking about back in the day? Funding for some of these projects has actually declined. So this is not really the spring of artificial intelligence. This is the winter of artificial intelligence. Because I think I've done enough doomsday saying when I said artificial intelligence does not exist. I won't linger on this one, but I just want to underscore this idea that there are competing views about what artificial intelligence might mean, and from a regulatory/legal perspective, I think the field manages to be particularly confused. And again, let me just say, it's exceptionally clear in areas like the ones in which my colleagues and a robust number of people in academia are working on. But by and large, people say, let's regulate artificial intelligence. And I'm really never sure about what we're talking about. And that's just fine, I think. But when our regulators are confused, and when collectively we are regulating things that are poorly defined or porously defined, I think we have a problem. And that's what brings me to this idea of monism. So that's the fancy word that for some reason I chose to use to convey this idea that I don't think we have any business with regulating artificial intelligence. I think that what we have been doing, we legal people, policymakers, regulators, I think that what we should be doing is to pay attention to segments of very specific areas of AI, broadly defined, but we have to be specific about what we're regulating. So it doesn't do us any good to have frameworks that apply to artificial intelligence in healthcare, period. Here are 7 overriding principles. Why? Because in healthcare, you'll have technologies that rely on deep learning, and you'll have technologies that merely rely on machine learning. And you'll have a few technologies that are called artificial intelligence, and really they're not. They just incorporate basic math. And I don't think we've done a very good job at distinguishing that. So let me give you an example, and because I'm Europe-bound in a couple weeks, I've been looking at some of the things happening across the pond. So I got this document that was produced by the European Parliament, a new framework and industrial policy for artificial intelligence, which never really gets properly defined, and robotics. Now, very, very different concepts, and yet mashed together as if they were a unity, as if there was a monist view of artificial intelligence. And under this umbrella, everything operated exactly in the same ways, and that's absolutely not the case. So why is it problematic? Why, what if, we call it artificial intelligence? Aren't we smart enough when we regulate to say, well, we're calling it artificial intelligence. What we really mean is professional advice, and we're regulating that field specifically. So what if we're calling it AI, and Anna, you think it's called something else? What are the practical implications? So I'll do the opposite of what the 2 previous speakers did. They looked into very specific areas. I'm going to look at the beginning and the end of the regulatory process. I'm going to look at the stage of incentives to innovation, so things that the law and legal systems do to make sure that we're funneling creative energies and funding towards the production of the technologies we want to have. And then I think in a much shorter way, because we've talked a little bit about this before, I'm going to look at the end of the spectrum. Okay, say we got the law right and we're getting all these technologies coming to market. What happened when, oops, things go wrong? So the idea of liability, and I think I'm going to attempt to show to you that if we keep talking about regulating artificial intelligence as a field, we might make some mistakes that we have made in the past. I also think that there are some good lessons from the ways in which we've regulated technology, and particularly in the area of life sciences and healthcare, that from a regulatory perspective we were able to make, and we probably should proceed with the same caution that we displayed in such cases. So let me start with this idea that if we say we are going to look at these emerging technologies in a non-nuanced way, but as the field of artificial intelligence, and we're going to look at what the relevant problems are, there are immediately 2 fields that come to mind. At the beginning of the regulatory process, I'm thinking about the field of intellectual property. This is a very, very large field, and some of the things I will say right now are slight, or more than slight, oversimplifications, but one of the main functions of the field of intellectual property is to provide incentives to the creation of technologies. How do we do that? We distort the markets. We distort the market for a number of reasons by awarding things like patents and by copyrights. Essentially, this is the reason that whenever you watch an episode of Shark Tank and somebody pitches something, all the sharks go like, do you have a patent? Is this proprietary technology? The law makes you a monopolist in the market so that you have an incentive to spend the money researching a particular technology so that you have an incentive to overcome the risk associated with failure. And an increasingly criticized trend of literature, of legal literature, says nowhere are these rights more needed than in the fields of life sciences / healthcare innovation, because this type of innovation, not only is it very socially valuable, but also it's particularly expensive and particularly risky. So on the side of intellectual property, we want to make sure that we get the levels of incentives right during the spring of technologies, because if we fail to do so, a certain strand of the discourse goes, we are going to stifle the development of these technologies at birth. So how does this play out in the field of artificial intelligence? There are a lot of calls out there for artificial intelligence incentives to go beyond the field of intellectual property. I think that's what Professor Price referred to as the uncool things, like grants and other prizes and other things you can give people to innovate other than these market distorting rights. But there are some people who say, hey, even though we already distort the market and give inventors monopolies that at least nominally last for 20 years and allow you to exclude every other competitor for the market for a chunk of time, these things are not enough. Why? Because AI, again, the very broad, porous definition of AI is different. AI is also harder to square with intellectual property regimes. What do I mean by that? Some people, actually a fair number of people, to my surprise, turns out they think that it will be very, very hard to get patents that cover AI-based inventions or certain features of AI technologies. One of the main problems is the opacity of these algorithms that we've heard mentioned several times today. From a technical perspective, this is why there might be a slight legal hiccup. The reason we distort the market, I told you, is because we want you to innovate. We want you to overcome the fear of failure, cost, etc., and come to the market with these technologies. But we don't merely distort the market. We distort the market also to force you, the inventor, is going to benefit from the monopoly or the quasi-monopoly, to force you to disclose the information that you have on this particular technology so that we can either improve on it or innovate around it. So there's this sort of trade-off. And when we ask of you, the innovator, to disclose to the patent office and eventually to your competitors how you've created this new technology, that description from a technical perspective has to obey certain criteria. It has to be very, very specific. We call it enabling. It has to enable your competitors to replicate, or at least to be able to understand and conceptually replicate what you have done. So we require that you share an enabling amount of information. Now, if you have opaque algorithms, some people are concerned with the fact that you cannot really fully characterize what the algorithms are doing. If you can't explain why your little app is telling doctors that a particular type of image is not pointing towards a malignant outcome, as opposed to another one saying that the outcome might be malignant and you should do X, Z, and Y. If you can't fully explain the process, you might have a disclosure problem in intellectual property, in the sense that you might be able to explain part of what you've done and what the invention does, but not the entire process. So we worry about opacity and opaque algorithms at many levels, but from a technical perspective, some people think we have a problem in this black box and in the patentability of this black box. As such, some people have suggested that not only do we need intellectual property rights, and we cannot do away with intellectual property for a host of reasons related to both domestic law and, for the time being, international law and treaties we are still a part of, but we can't do away with these rights, but some people are concerned that these rights are going to be very hard to get, and we should be creating additional incentives for innovators in the field of artificial intelligence. I think that this is a form of legal reactivity, so the second portion of the title. First, it's not true that all algorithms are opaque. In fact, some of them are quite understood these days. So this idea that incentives to AI from an intellectual property side of things are insufficient, and we should ratchet up the types of protections that we're giving to innovators in this field, I don't think this tells the whole story. I don't think that this looks into the different ways in which different embodiments of AI currently operate. I think we have an opacity problem, but that's a really minor problem because only a fraction of the AI technology out there is actually fully opaque. So I get a little bit concerned when I read that the incentives to artificial intelligence innovation are insufficient, and probably, they are, but this is not the only field of technical innovation in which we have insufficient incentives. But certainly what I don't want to see is the Patent and Trademark Office giving more rights to AI innovators. I don't think that in this particular regard they are special. I don't think that all of them face technical hurdles in patenting their things. And I certainly don't want to see, in other scenarios, the FDA, for instance, giving more market exclusivities, which are things that are separate from intellectual property rights, but also prevent competitors to come to market if the AI in question has some sort of medical application. I don't want to see market exclusivities created specifically for AI. We do that. In addition to intellectual property, we create FDA-administered rights when we have certain types of medical technologies that are especially valuable, at least from a social perspective, I think. So when very complex drugs, large molecule drugs, certain types of proteins, etc., come to market, you get your patent protection, and on top of that, you get quite lengthy exclusivity market periods granted independently from patents from the FDA. So these are the things I would not like to see in the field of artificial intelligence. Why? Because the field of artificial intelligence encompasses many things, and if you don't have a technical problem because your algorithm is not opaque to begin with, you're a different thing. And this idea that we just don't sufficiently incentivize you should not apply in the first place. But even if you are opaque, I don't think that opacity per se creates any new problem. Why is that? The patent system and the PTO panicked a little when inventors starting to bring applications that involve living organisms, because that's not what initially the patent system back in the days of Venice in the late Middle Ages created the patent system. They were thinking about things like blown glass. They were not thinking about living organisms that mutate all the time. So how do you describe a living organism that changes all the time? How can you put down in writing all the possible mutations and iterations of said organism? And what we did back in the time was to say, okay, this is still technology. It's not blown glass like it used to be, but it's a form of technology that needs to be characterized. So one of the things we did back in the day was to say, fine, give us a description of, say, a bacterium, and then deposit a sample of your bacteria. And experts in the art will be able to look at your partial description and at the sample, and even if you can't fully characterize it, hey, this ought to be enough. And turned out it was enough. So when we worry about things like incentives and make all the levels of legally induced incentives that we create artificial, distortions to the market hinge on things like algorithms are different because they are opaque. There's an immediate but. Well, in some cases they are, but not in all cases. So we should not be ratcheting up levels of intellectual property protection because some or fringe of algorithms are opaque. And even when they are not fundamentally different, I think. Yes, you need to worry about them for a host of reasons, but when you talk about science and innovation policy, and particularly from an IP perspective, we can get around some of the things that worry you. So we deposited bacteria, just share part of the algorithm or share the initial algorithm with us, share some of the things that are known about the algorithm, some of the outcomes. We don't need to get into the black box to legally protect your innovation. So this is one embodiment of the IP side of things, so at the beginning of the innovative process. Now say that irrespective of the level inappropriate or appropriate of incentives that currently we have in place to induce innovation in the field of AI, we have these technologies and we're getting towards the end of the process. We've created the AI, we've gotten it, if need be, through FDA approval, we're marketing it, and something goes wrong. So this idea of liability has popped up a few times. We've seen that at the beginning of the process we might worry about incentives, but liability or the threat of liability or the uncertainty about liability might also be a great deterrent to, one, innovation in the first place, the creation of these problems. If doctors are indeed worried that might be held liable if an algorithm provides incorrect information / advice, and if they come to rely on it, that can be a great deterrent to widespread use of the technology, to even to development of the technology that might have repercussions at the level of patient trust in treatments that incorporate some component of artificial intelligence. So I'm going to go now to the end of the process, and I'm not going to hammer anymore on this idea that there are different embodiments of artificial intelligence, but I would like to revisit this idea about AI being special versus AI being not particularly special. And I must thank Professor Haupt for going into the nitty-gritty of advice to doctors, patients, in the doctor-patient space. So you've seen the really nuanced version of the problem. I'll give you the panoramic version of the problem, which goes like this. Is artificial intelligence fundamentally different as a technology that it doesn't fit the liability molds that we're used to work with? And I think the answer is no, even though our personal relationships and even institutional relationships with technology are fundamentally changed. I think that something went wrong with the technology is essentially a scenario that we've seen over and over from the time in which boats got radios, and that was the technology was all the rage, and even before that. So let me explain what I mean by that. There's something called the restatement second of torts, which is a very famous comment, involving unavoidably unsafe products. This is a category of products that by and large was developed to deal with many of the things that I'm guessing a lot of you in the medical profession have to deal with on a regular basis. Things like vaccines and therapies and other forms of technology, really, that we think are extremely valuable from a social perspective. I'm not going to say all of us think vaccines are incredibly important and should be administered, but a healthy majority of people agrees with the conventional scientific wisdom on the prospect on this statement. And we've already referenced here other types of drugs or biologics that seem to work, and as such the FDA approves them and doctors prescribe them, they come to market, but sometimes things do go wrong. Sometimes they don't work the way they work with most other people. Sometimes injury and death do occur. And we've all heard stories in connection with vaccines, with biologics, with small molecule drugs, with procedures that should have gone smoothly and did not. And yet, we allow these drugs, these procedures to be performed, these drugs to come to market. So the law has always made space for this category of things that are unavoidably safe, but we think there are compelling social, if nothing else, social reasons to bring them to market and make them available to doctors and to patients. And what our tort law system did was to say, look, we're just going to admit upfront that things like vaccines and drugs can cause injury, might even cause death. We're going to establish a set of requirements that you must comply with if you're bringing these products to market. So Professor Price was not very persuaded by labeling requirements, but these are some of the things we've done to ameliorate this idea that we're bringing risk into the market, and particularly into the medical space. And as long as you comply with those requirements, as long as you're practicing your profession as you should, we are going to say that you won't be held liable. You don't have to have this sword hanging over your head all the time, and go ahead, practice your profession, and know that if some outcomes do occur, you don't have a liability regime in place that's uncertain. You know exactly what's going to happen, you know what are the things you have to comply with, and everything is going to be okay from a legal perspective, right? So we're eliminating that uncertainty, that sword over your head, simply because if we don't do it, these products are not going to come to market. We're not going to get buy-in. And I think the same happens in the field of the different artificial intelligence-related technologies that we are familiar with and that we're likely to have come to market in the foreseeable future. In fact, I think artificial intelligence as applied to medicine is not different from vaccines, from biologics, from drugs in general. It holds great promise. It's not fully explainable in some cases, but then again, so aren't many of the drugs that have come to market over the past 20 years. We can't fully characterize them. So what is the real difference from a regulatory perspective? So I would say that, how much time do I have left? Out of time? Hey, so I'm going to very briefly say that one, I, as you probably can tell, worry about treating AI from a regulatory perspective as if it were one thing, because I think we stretch arguments too far, and with that, we might actually stifle innovation and creativity. But I also think that good news is we have a very plastic regulatory system, and we can make fit these new technologies, particularly in the medical field, into, if nothing else, analogies with technologies we've successfully, I would argue, regulated in the past. And that's where I'll stop.
I think we have time for about one question.
Thank you for the talk. That was very interesting. I just am curious with the analogy between black boxing vaccines and black boxing AIs. I wonder what you think about. I think that there's a disanalogy when it comes to race, gender, and class bias in artificial intelligence systems. Like if somebody created a vaccine that only worked on white people or worked to a degree far more effectively on that group, I'm just curious how that would fit into this framework.
Yeah, no, you're absolutely correct. The analogy is not perfect, but I'm using the analogy for different purposes. So I leave the profound matters of inequality, discrimination, bias to smart people like Professor Nicholson, Professor Earby at the law school who work on those topics. And you're absolutely correct that those are legal / to some extent regulatory problems. I'm looking elsewhere in the regime, and I'm not saying that liability and intellectual property are completely separable from questions of bias and race and underrepresentation, but I'm dealing with a problem that by and large lives in the different area of the legal ecosystem. So basically, I want people to create these technologies without one being too afraid of things like liability or having too many intellectual property rights to create or having uncertainty about the types of protections the law might give them to the technology itself, so the things they can do to monetize the technology and justify the investment. And what follows is that if we get that right, that the idea of certainty or ways in which the law can help you bring these technologies to market, if we get that right, people will get the technology wrong. Some people will get them right, and some people will get them wrong. But we've gone over that first hurdle, and then we bring the likes of Professor Price and Haupt and Professor Earby to deal with the other issues. It's just too much to deal with in one fell swoop.
Let's continue that conversation over a break. And thank you, Elizabeth. Thank you, Anna Santos-Rushman.